So you want to pass your real estate exam? Well, how are you going to do that? With practicing lots and lots of questions for national and Texas state. And of course, your vocabulary is primary. All right. So I repeat myself over and over. Vocabulary is crucial because you're learning a new language and it'll help you answer the questions and understand them. So please do not bypass your vocabulary. All right, here we go. So we're continuing with national questions today. And on the second half, we will be doing state questions. And it's the same book we did. We're continuing with national questions
Okay,
today.
hold on. Let me shut down my
my YouTube channel. I just refreshed it. Okay, so just for those of you who may not have been here, okay, the book that we're using is this one right here, and it's listed in the description. There's a list of books in the description that you can purchase from Amazon. And I do get commission from Amazon. However, it doesn't cost you anything except for your purchase. So just want to disclose that. Hi, Carlos. How are you? Thanks for joining us. Well, darn, I had it set up good. Had a busy day today. Went and met a client at a title company. Went and bought some letters and envelopes and not letters, paper, because I am now sending out expired letters to listings on the MLS that have expired because the market has changed. And so now there's the buyers are pretty much carrying it right now, even though sometimes there still are multiple offers. However, we didn't used to have many expireds when the market was extremely hot. We didn't have enough listings. So pretty much everything was selling. All right, so here we go. National questions applies to all 50 states in the United States. So please participate. Anybody watching the replay, hey, fast forward wherever you don't want to slow down or you want to speed up, because the class is intended to have students participate during class and type in the question number and the letter answer. Should you get it incorrect, then I will help you understand it. Okay. Hi, Cindy. My good old faithfuls here that are soon going to be realtors, right? You're going to pass. All right. The cost of constructing a functional equivalent of a subject property is known as, so we're dealing still with appraisals. A, reproduction cost. B, replacement cost. C, restitution cost. Or D, reconstruction cost. So the cost of constructing a functional equivalent of a subject property is known as, so those of you who have insurance, you probably get asked that by your homeowner insurance agent as to if you want to have, yes, B, replacement cost. Because sometimes if you don't ask for replacement cost, it may not cover everything should a house burn down or get hail damage, especially when it burns down, right? Because they have to replace the house similar to it with current material costs. So whenever you go to your insurance person, make sure you have coverage of replacement cost and not just 80%. Okay, number 52. An office building lacks fiber optic cabling to accommodate the latest communications equipment. This is an example of A, physical deterioration, B, economic obsolescence, C, incurable depreciation, or D, functional obsolescence. So the building lacks, okay, fiber optic cabling. It can be installed, right? if it's available in the area. So what is it? Physical deterioration, economic, or functional obsolescence? I'll let you know it's not C. All right, so we have D. Yes, that is correct. Hey, Carlos, I'll ask you a favor to please type the question number and the letter answer so that we know which question you are referring to or which question you are responding. So yes, it is functional obsolescence, right? The property doesn't function comparable to others, so they have to come and install it. And it might cost you money, it might not. So if it's not provided in the area, then it's going to cost a little bit more money to wait until they provide it in the area, and then you can add it to the home. Physical deterioration is what? Wear and tear on the property, right? It can be cured. It takes less money than functional obsolescence. And what is functional obsolescence? When all the houses now are in demand are 3 bedrooms, 4 bedrooms, 2 bath. And this particular house has 2 bedrooms, 1 bath. So the functionality of that home is not in great demand. So in order to become up to par to competitive properties, right, it's going to cost more money to make it functional, 3 bedroom, 2 bath. And economic is if there's something in the area that came in, no matter what you do, you invest hundreds of thousands of dollars to the property, it is not going to take away the defect of the economic or the environment that causes a depreciation on the property. All right, Carlos, you're welcome. Thank you. All right, number 53. A home is located in a neighborhood where homeowners on the block have failed to maintain their properties. This is an example of A, curable external obsolescence, B, incurable economic obsolescence, C, functional obsolescence, or D, physical deterioration. So keep in mind, so you're looking at certain things can be cured, right? And other things may not. So it says a home located in a neighborhood where homeowners on the block have failed to maintain their properties. However, even though the homeowner may be obtaining, taking care of theirs. So it's what? The environment, right? The exposure, what's around it. Yes, so that is incurable economic obsolescence, B. The particular owner concerned can't cure it. The other owners have to cure it. And some instances, it may not be curable. It is considered economic obsolescence because it depreciates the property, and the owner of a particular property that's concerned, can't do anything unless they go and violate the neighbor's privacy and go and do it themselves, right? So that's why it's called incurable economic obsolescence. All right, let's see what the answer says. Economic or external, okay, obsolescence is the loss of value due to adverse changes in the surroundings of the subject property. And what is the subject property? The person that's concerned about it, the property that's for sale, or the property that's under contract. Since such changes are usually beyond the control of the property owner, that is the subject property owner, so it becomes economic obsolescence, and it impacts their value. It causes depreciation, and there's really nothing they can do about it unless they go and talk to the neighbor and win them over and get their trust, and it gets done. So Carlos, you said deterioration. Well, it's deterioration of the neighboring properties. However, we're talking about, okay, it's impacting, let me go. You said curable external obsolescence. It's not curable by the concerned homeowner. It's curable by the other owners. However, not by the owner that is having a concern and it's impacting their property to depreciate until the neighboring properties end up taking care of it. So it says, in a neighborhood where a home located in the neighborhood where homeowners on the block have failed to maintain their properties, not the particular homeowner. All right, number 54. In appraisal, loss of value in a property from any cause is referred to as A, deterioration, B, obsolescence, C, depreciation, or D, deflation. When a property loses value, what is that called? And actually, if it's an investment property, it's a good thing, right? It's a tax write-off. It's a tax shelter. Hi, Lisbeth. Hi, Ruth. Yes, the answer is C, depreciation. And all investment homes that we use for a write-off, right, or personal property, it has a lifespan. And as far as I know, it's still 27.5 years that an accountant will depreciate every year. Hi, Marcella. Oh, Marcella. Okay, I'm going to ask you to go to StreamYard.com/Facebook and give StreamYard permission to post your Facebook name on here, because I am using StreamYard to stream to YouTube and to Facebook. It's really quick. Just click on that link. I put it on Facebook and I put it on YouTube. Click on that link, go to the website, and it's really quick, okay? Almost in the snap of a finger. Thank you. So yes, depreciation. Number 55. In the cost approach, okay? What kind of approach? There's 3 different appraisal approaches, right? CMA, cost, and income, right? So in the cost approach, after estimating the value of the land and the cost of the improvements, the appraiser, doesn't all fit. Okay, it's going to end up being small. Oh, there we go. The appraiser does what? A, estimates depreciation, subtracts depreciation from cost, and adds back the land value. B, subtracts deterioration from cost, estimates land depreciation, and totals the 2 values. C, estimates depreciation of land and improvements and subtracts the total from the original cost. Or D, estimates obsolescence and subtracts from the cost of land improvements. So remember, when there's a cost approach, they've got to look at the land, they've got to look at the improvements, and something else. So only one correct answer here. I mean, that's typically the case, right? However, there sometimes may be 2 answers that could be accurate. Type your answer in the chat. Ooh, so I forgot to type them on 54. Oh man, I'm way behind here on Facebook. Type your answer in the chat. Where's everybody? No responses. 650. Oh. So what were the answers here? No answers? Okay, you're going to see a message come up. So that's for the answers I failed to type on Facebook. Okay, so I've got C, C, Ooh, okay. Let's review these questions here. Hold on. The answer is actually A. Okay, and let's review that. Why? Okay, so let me just show the prior answers that I hadn't posted. These were on Facebook. Okay, so the cost approach, it takes the value of the improvements, subtracts the depreciation cost, and then adds back the land value. They do not depreciate the land. Some of you answered D, estimates depreciation of land and improvements. No, the land is not depreciated, just the improvements. Land value pretty much it's not depreciated, okay? It's the improvements, because the cost of the improvements, they get outdated, wear and tear, but the land is there. Okay, you can't move it, you can't destroy it. Well, let's see, an earthquake, hurricane, river, or something like that, mudslide, yes, can destroy some of it. So it is not, you only estimate depreciation on the improvements, whatever is above the land. The building, the dwelling. Okay, do you all understand that? All of you actually answered C. The answer is A. Y'all get that? Type a yes or no in the chat, if not, so that I can review it some more. Wake up, wake up, wake up. Come on. All right, well, I'm moving on. Number 56. Which regulatory entity/code establishes standards for an appraisal's methods, reporting methods, and disclosures? A, Financial Institution Reform, Recovery, and Enforcement Act, FERIA. B, Uniform Standards of Professional Appraisers Practice. C, National Association of Realtors Code of Ethics. Or D, Federal Appraisal Regulations and Licensing Board. Oops, there we go. So which regulatory entity or code establishes standards for an appraiser's methods, reporting methods, and disclosures? No, it is not A. That is who enforces it, okay? However, the standards, okay, are come out because financial institutions are the ones that request appraisals, right? Because they want to protect their value and make sure they're loaning the right amount and not loaning more than what a property and appraised. Owners can also ask for appraisals so that they know the value. However, the regulatory entity, okay, and establishes standards for appraisal methods is the Uniform Standards of Professional Appraisal. So the USPAP is the professional code of conduct established by the Appraisal Qualifications Board that regulates appraisals practice in the USA. Standards relate to reporting requirements, methodologies, and property disclosures to clients and the public. So 656B. B. So they provide and establish the standards. The other one had to do with, the value and who requested and who enforces it. It was A. When they another question that we did last week, maybe Saturday. All right, so that was the end of, I think it was the appraisal section. Now we'll go into finance questions for national. So how do you like our temperature now, man? It's getting a little cooler, a little bit, okay? Okay, let's see. Some of you answered B, okay? Carlos, Marcela, were you able to, I guess you didn't get a chance to go to the Facebook page that I said, streamyard.com/Facebook, so everybody can see who you are. And because I have my Facebook up so I can see you. All right. 56 was not D. Not the Federal Appraisal Regulation and Licensing Board. Okay, it's the uniform standards. It's which regulatory entity code establishes standards for an appraiser's methods, reporting methods, and disclosures. Uniform standards of professional appraisal practice. Okay. So it's not showing your name as Marcela Galvan on here. See how we see Ruth and we see Carlos? When it ends up getting approved, then we'll be able to see your name. Okay, maybe there's a glitch with the system. Okay, financing. What is a lien theory state? A state in which a mortgagee, who's the mortgagee? Okay, type on the chat. Who is the mortgagee? Remember EEOR? Okay. The mortgagee is the lender, right? So what is lien theory? A state in which a mortgagee holds legal title to a secured property. B, a state in which a mortgagee has equitable title to a secured property. C, a state that allows real estate owners, creditors to record liens against the owner's property. Or D, a state in which a lien is considered as a conveyance. Yes, very good, Carlos. The mortgagee is the lender. Okay, so in a lien theory state, which one is correct? A, B, C, or D? Okay, no, it is not C. Take another attempt. The answer is actually B. A state in which mortgagee has equitable title to a secured property. And in a when there is a, remember, if it's a mortgage, then you have a judicial foreclosure. If it is a deed of trust, we have a non-judicial foreclosure. So B as in boy. Let's see, we had C, a state that allows real estate owner creditors to record liens against the owner's property. No, it's, in a lien theory state, the mortgagee, the lender, has equitable title to a secured, to a secured property. Okay, Miss Cindy is back. So they have the equitable title holders cannot transfer legal title to real property. So who owns the legal title? It's the mortgagor, right? They have the legal title. However, Should the borrower default, that's why the lender has the equitable title and they have the property as collateral, as the security. So if they default, then the lender can foreclose and get legal title. No, Ruth, the mortgagee is the lender, not the borrower. Okay, the borrower is the mortgagor. The borrower, okay, is receiving, the loan from the lender, and the lender is receiving the collateral, the security against that property, the document. Okay. And just a little note, in a when there's a deed of trust or a mortgage, there is a promissory note, and the promissory note is not recorded, right? The warranty deed and the deed is and the deed of trust or the mortgage itself is recorded. All right, number 2. What is the function of a note in a mortgage or trust deed financing arrangement? A, it is the lender security instrument in the collateral property. B, it is evidence of ownership of the mortgage or trust deed. C, it contains the borrower's promise to maintain the value of the property given as collateral for a loan. Or D, it is evidence of the borrower's debt to the lender. So when they say a note, okay, they're talking about the promissory note. In the old days, we could write it in a piece of paper. Hey, you loan me money. I promise to pay you this $100. $10 a week or something like that. Well, that type of is not recorded. Okay. However, it is evidence that borrower's debt to the lender. Hi, Anai. Thanks for joining us. However, if this is Anai, I'm going to ask you to do the same thing that I asked Maricelas. Go to this website, StreamYard.com/Facebook, and give StreamYard permission to post your name on here. It takes, less than a minute. All right, number 73. So I think everybody got that one right. Yes. All right, number 3. When home buyer Henry pledges his new purchased home as collateral for a mortgage loan, the evidence of the pledge is the what? A, trust deed or mortgage. B, promissory note. C, loan commitment. Or D, loan receipt. Home buyer Henry pledges his newly purchased home as collateral for a mortgage loan. The evidence of pledge is what? A, B, or C? Okay, so far I have A. And the answer is A. It is a trust deed or mortgage. Okay, that is the home is the collateral, and it is going to specify in the trust deed. Okay, so it is the actual pledge. So the homeowner Henry pledges his new purchased home as collateral. That pledge is the trust deed or mortgage. Hi, Gina. Thanks for joining us. Oh, I have 2 Galvans today. I have Marcela Galvan and Gina Galvan. So 7.3A. All right, number 4. The borrower in a mortgage loan transaction is known as the A, mortgagee, B, mortgage or, C, lienor, or D, trustee. So who is the borrower in a mortgage or in a deed of trust? Hi, Monica. 7.4. Your answer in the chat. Okay, B, 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 B. Yes. The answer is B, mortgage or, right? You're going to say, okay, but a mortgage, the OR is a giver, right? Well, the mortgage or is giving back, okay, the security, the collateral to the lender, okay, in the trust deed, right? That's the collateral. Well, the property right is the collateral, but the trust deed explains it all. Very good. Everybody got that one right. All right, number 5. If a borrower obtains an interest only, okay, pay attention, interest only loan of $200,000 at an annual interest rate of 6%, what is the monthly interest payment? A, 1,200, 6, B, 600, C, 500, or D, 1,000. So they have an interest rate, interest only, so they're only paying interest every month. It doesn't allow the principal to decrease every month. So what would be the monthly interest payment? In essence, their monthly payment, period. Okay, so far I've got 75A, A. No. Okay. So how many months is there in a year? There are 12, right? So the annual interest rate is 6%. Right? So 6% times 200,000 is what? Yes, D. You've got to divide by 12. Right? So 6% times 200,000 is 12,000. Divided by 12 gives you 1,000 per month. Remember that. You've got to divide by, so I think some of you divided by, you took 1,200. However, you have to divide by 12. So 200,000 times 6.06%, and then divided by 12. Okay. So on your calculator, right, you've got 200,000 times 0.06 gives us 12,000, right? Not 1,200. You move the decimal back 2 decimals, and then you divide that by 12, and you get 1,000. Very good. 7. That's a simple math problem. So go back and review your formulas or what interest rate only means. So annual means it's 6% for the whole year. So you got to divide by 12 in order to get monthly interest. Okay. All right. Number 7.6. Okay, let's see. I've got Ruth asking 7.3. Let's go back to 7.3. Bye. All right. 7.3 says when homebuyer Henry pledges his newly purchased home as collateral for a mortgage loan, the evidence of the pledge is the trust deed or mortgage, B, promissory note, the loan commitment, or the loan receipt. Okay, so on here, okay, it is not a loan receipt or loan commitment. A loan commitment is that the lender agreed to loan them the money. Okay, that doesn't specify the terms of the loan, how much it is, and all the details. A promissory note is not recorded. So then the public is not going to know, because anything that has a lien on it and is pledged back is going to have the lender's name on it, on the warranty deed, okay, on the deed of trust or the mortgage, so that the public knows if they're going to buy that property that there could be a lien. And the way to find out is by going to the county courts and asking for by having the description on that property or who the owners are. They can get whether there are liens attached to that property. Nowadays, you can do it online, and or you can, go get a title report. However, it's normally done at the courthouse. So a promissory note is not public information. That's between the lender and the mortgagor, right? The buyer. So that is private. Okay, it details, hey, I borrowed $500,000. This is how I'm going to pay it back. Okay, it's just a promise to pay back. And a loan commitment is if the lender agrees, okay, to loan a loan receipt. Now, okay, you get a monthly statement. So the trust deed is in states like Texas. Okay, maybe about 50% of states or less have a deed of trust, and the others have a mortgage. Okay, you get it. Thank you. Okay, and the difference between deed of trust or trust deed or mortgage is the foreclosure process. So in a mortgage, it's a judicial. They've got to go to court to get a judgment to sell the property and foreclose. On a deed of trust, it has all the explanation, all the details on what the trustee who holds onto the title is, the equitable title is what they have to do in order to foreclose or how do you call it? Accelerate the loan. Okay. All right. So you got it. Very good. Glad I could help. Number 6. Oh, I forgot to turn the radio off. Can you all hear the radio? Is it bothering you, the music on the background? I have the radio on going all day, and I keep the radio on for my cats when I go out, driving clients or go outside of the house. If it is bothering you, let me know and I'll turn it off. All right, number 6. If a borrower's monthly interest payment on an interest only, again, only interest loan at an annual interest rate of 6% is $500, how much was the loan amount? So, you'll want to use the T formula to calculate this. Okay, so the T formula is what? I wish I could write on here, but I can't. So calculate. So they have an interest-only loan, and this time it's telling us how much their interest payment is. So in the other question, okay, here we multiplied 200,000 by 6, and that equaled the payment. So if here you're multiplying, would you be dividing here? What do you think? No calculations yet? So it's going to be, well, let me give a chance to somebody. So here, since it's an annual interest rate and we know the monthly interest is 500. So we're going to have 500 times 12, okay, because the full interest is for the whole year. So 500 times 12 is what? 6,000? 600? 6,000? What is it? Come on, nobody's answering. And then when you multiply 500 times 12 so that you get the whole year, that's going to be what? 6,000, right? Then you divide that by 0.06, and it gives us a value of, yes, B, 100,000. So you're going to say, well, you said divide, right? Well, yes. However, it's asking here. So the payment on an interest loan at an annual interest rate is 6%, and the monthly payment is 500. So you're, in order to get what the property value is, right, you've got to multiply by the whole year. In the other one, we divided by 12 after we came up with a value, right? So on this one, we had 200,000 times 6%, okay, and then divided by 12. This one, oh, sorry, we're multiplying by 12, the $500 value, and then divided by 6%. Okay, only one person risked it. Number 7. A borrower of a 50,000 interest-only loan, again, interest-only loan, makes annual interest payments of $3,750. So that's already telling you what the annual interest-only amount that they pay is for the whole year. What interest rate is the borrower paying? Oops. It's kind of like the interest rates that we have now, because the interest rates have gone up. Yes, Cindy, the answer is A, 7.5%. So you have the interest for the whole year, divide that by 50,000, and we get 7.5%. So interest amount for the whole year divided by the borrower loan, or the loan amount, gives us the interest rate. If we multiply the interest rate times 50,000, then we get 3750 for the whole year. We want it monthly, we divide by 12, right? So very good. 7.5A. I mean 7.7A. Okay, 7.9. I got to go smaller. All right, number 7.9. Which of the following is true of an amortization loan? Okay, you've got to know what amortization is. Okay, so the other one, interest only, annual percentage rate, those are all vocabulary, right? At the beginning of the video, I said you practice lots and lots of questions. However, you must know the vocabulary. So which of the following is true? It's a correct statement about amortization loan. A, the amount of annual interest paid is the same for every year of the loan amount. B, part of each periodic payment is applied to repayment of the loan balance in advance, and part is applied to payment of interest in arrears. C, except for any points that may be paid, the interest on the loan balance is usually paid in advance. D, the interest rate is reduced each year to maintain equal payments, even though the outstanding loan balance is smaller. So what is true about amortization? Oh, I passed number 8. Okay, sorry. I'll come back to number 8. Yes, I got it. Thank you. No, Jaylene, this is national, but we'll be going into state real shortly. We've got 2 more questions here to do, Jaylene, and then we'll be going into state, Texas State. So the answer here is B. Part of each periodic payment is applied to repayment of the loan balance. So that is the principal. So in an amortization loan, when it's amortized, it has equal payments for loan and it has the same payment every month, okay, except there's a certain amount that goes to the loan balance, which is paid in advance, and part is applied to the interest, which is in arrears. Okay, the lender charges interest and then we pay for it. I skipped 7.8, so I'm going back to it. So I'll be back. So all right, number 8. Okay, so at least I know you all are awake, right? And not me. A click of the thumb, okay, rolling the mouse ball. Okay. So anybody watching the replay, we're going back to do 7.8. Maria borrows $100,000 and pays 2 points for the loan. What is a point? Okay, vocabulary. How much does she pay in points? So 100,000 loan and 2 points. A, 200, B, 2,000, C, 1,200, or D, it depends on the interest rate. So far, I've got BB. Yeah, you guys are quick on this one. Anybody else? Anybody else? Going once, going twice. Dun, 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 dun. Yes, gone. The answer is B. It is 2,000, right? 2 points. 1 point is equivalent to 1% of the loan amount. Not the purchase price, not the list price, but the loan amount. So 2 points times 100,000 gives us 2,000. Very good. All right, last question on the national. For a loan that is not backed by Federal Housing Administration, known as FHA, or Veterans Administration, known as a VA, and for which the borrower is making a down payment of less than 20%, the lender is likely to require the borrower to obtain what? A, subrogation agreement, B, private mortgage insurance, known as PMI, C, a letter of credit, or D, co-signer on the note. Okay, this is something that the lenders want in order to make sure that they get paid, okay, like we get if something goes wrong, Okay, like we have homeowners insurance. If we have a disaster, the insurance will cover it, or a certain percentage. Health insurance, it's for whenever there are disaster situations or needed situations, right? It's protection. Yes, it is B, private mortgage insurance. Does anybody know, type it on the chat, what it would be for the FHA? Because VA loans are guaranteed by VA. What is it called, the initials on what is paid for on the Federal Housing Administration, and it's paid throughout the whole loan? Type it in the chat. So we know that when it's not FHA or VA, okay, it is PMI, private mortgage insurance. What is it when it is an FHA loan? Because FHA loans are insured. VA loans are guaranteed. Yes, Monica, awesome. MIP, mortgage insurance premium, and it stays for the whole term of the loan. So it's an extra payment, an extra charge that's added to the mortgage. Okay, like we pay car insurance, owner's insurance, health insurance. Yes, very good, very good. Awesome, awesome. Can you tell I love the word awesome? All right, so let's transition into state questions. So if you have any national questions, let me know before we start the Texas state questions, but give me a moment to transition, okay, into the Texas state questions. And for all of those of you that were on the national here from other states, hey, remember to go to my YouTube channel, YouTube AgentPrep. And if you haven't tapped the subscribe button, please go over there now and tap that subscribe button. Click the little bell so that you're the first to get notified every time I go live or I upload a new video. And give me a thumbs up if you found this video useful. If not, hey, don't give me a thumbs down. If you can't say anything nice, hey, don't say anything. All right. Let's keep it positive. However, I know there was quite a few of you on YouTube, so send me some love. Okay, so there were no questions, nothing like that. All right, so let's see here. So we're going to start out, let me type here, Texas state questions and answers. Oh, I said exes. No, it's not all my exes are from Texas, because they're not. But it's Texas state questions, okay? And so I'll be right back. Read that question and type your answer in the chat. Okay, I am at home. I'm a human, and I have four-legged kids. And it's their dinner time. If not, they're going to meow, meow, meow throughout the rest of the class. Does anybody have four-legged kids? That's what I call my my pets, four-legged kids. All right, so far I have A. So let's see what it is. Constructive eviction. Remember, there's constructive notice or actual notice. Is best described as which of the following? A, attendant self-eviction, where the tenant with notice abandons the apartment due to the landlord's failure to maintain habitability. B, a tenant abandons the apartment and the landlord makes the vacancy official by filing constructive eviction notice. C, a tenant in a dispute with the landlord withholds rent until his or her deposit is returned. Or D, a landlord forcibly evicts a defaulting tenant in lieu of a writ of possession. So Jaylene says, ha, I have 4 cats and 4 dogs. Man, that reminds me of when I was in Oregon. We had 9 cats and 4.5 dogs until we adopted our neighbors. We had 5, but we had 32 acres. And then Lisbeth has 1 dog and 1 cat. So right now I have 2.5 cats. You know, say, how the heck can you have a half cat? All right, so the answer is A. A tenant self-eviction where the tenant with notice abandons the apartment due to the landlord's failure to maintain habitability. Right? That's a responsibility. Yeah, so I borrow my neighbor's dog, so we go walking and she's here keeping company. And then I have 2 cats, and my neighbor downstairs owns a cat that hangs around with us most of the time. Yeah, wow, awesome. I installed a little kitty window or kitty door, and so the cat comes in. So sometimes I have 4 animals inside my house or inside my condo. Let's see here. Oh, man. Yeah, I love animals. I'm an animal lover. I'm a nature lover. And so in Oregon, we had 2 properties adjacent right next to each other, and a total of 33 acres. It was gorgeous. I miss it. We had a creek, got to see the beavers, the deer, porcupines, skunks, not armadillos. I didn't see any armadillos over there. You know, snakes, bear. All right. Number 17, right? Yes. Okay, so let's see. Carlos says, explain constructive eviction. All right. So constructive eviction is when you notify the public in a recording, or they go to the court. And then, so it's a tenant self-eviction where the tenant with notice. So the tenant gave notice, right, and probably presented it in court. So everyone else is aware. Actual notice, if you go just to that person and you notify them, that is actual notice. Constructive notice, it goes to being recorded, goes in front of a judge, or the public can know about it because the landlord failed to maintain habitability. So that tenant, see, self-eviction. So you do a self-eviction, you go to court. Okay, and it's a small county court, okay, justice of the peace. They're small courts and you can get quicker decisions. And so they did it officially. Actual notice is I just come to you and give you the notice and make sure that you are aware. In constructive, you have to find out, either maybe a policeman will go deliver it, but constructive notice can be put in a newspaper, in the public records, recorded, or with the judges. And whether that person knows or not, okay, then they're responsible for knowing. Why? Because they have a property that is not habitable. So they're already aware that somebody could come after them or somebody could report them. So that is a constructive, means it's recorded, or it goes to a court. It's a formal way, okay, of giving notice so the public also knows. Actual notice is I'm handing you the notice. I'm letting you know verbally. Okay, and the constructive notice, the actual, let's say in a divorce, for example, okay, constructive notice, it is filed in the court and it's publicized in the newspaper. Well, that individual may or may not know. However, they know there's maybe an issue going on, but sometimes they're surprised by, everybody else knows, right? Because they read it in the newspaper, and if they don't know, well, the spouse didn't go and give them the notice and verbally say, hey, I'm filing for divorce, I'm letting you know in advance. Well, no, right? Because you become adversaries in a divorce. And here is an adversary situation. So they go directly to the legal process in order to make it happen. So that's nice, Lisbeth. You're on my good side. You like animals. Well, I get along with most people. Every now and then I can be hard-headed and stubborn and very direct and very formal. And you know what? I used to think I've got to please everybody. Well, we don't. So I'm not here to be loved. I mean, yes, I want your love. Okay. Oh, you got to see my face. Okay. I was doing some little signs. Yes, I want your love. Okay. However, you don't have to love me in order to like what I teach. As long as it helps you, hey, it's good, right? So I've learned that sometimes we let go of individuals that do not benefit, okay, our way of thinking, our goals, our ambitions, our drive, because there will be individuals which we call the naysayers. A lot of naysayers out there that will discourage you for some reason. Maybe it's their own insecurities, their own lack of knowledge, or their jealousy, envy, which I never used to think existed, but it does. The envy and jealousy does exist. And it can harm you if we allow it. It can harm us if we allow it. Okay, so I did post the answer. All right, number 17, non-judicial foreclosures. Okay, I mentioned them a little bit ago, but not everybody might have been there because I was doing national. Non-judicial foreclosures, like most legal proceedings, require that proper notice procedures be followed. In this proceeding, the notice of sale must precede the sale date by A, 7 days, B, 14 days, C, 20 days, or D, 21 days. Remember, this is in the state of Texas. Every state has their own foreclosure process. And so in Texas, we have a non-judicial foreclosure. It's already specified and described in the deed of trust as to what the trustee will do when a borrower is in default. Yes, very good so far. Oh, no, it is not C. The answer is D, 21 days. Okay, in Texas, it is 21 days. It's a very short foreclosure process, and the trustee, okay, who holds the title for the lender, okay? They're the individual that the lender trusts in order to follow through with a legal proceeding like a foreclosure. Non-judicial means you don't have to go to the judge. You don't gotta go to the judge. Here comes the judge, right? Well, you don't need a judge. It's already in the deed of trust, and they will file it. And so it becomes a constructive notice. However, they have to start sending notices to the borrower in advance prior to the foreclosure date or before actual filing of a divorce foreclosure notice, and see if they can cure it. Okay, so they'll be given a little bit of time to see if they can cure it, but not very long. Texas, a property can get foreclosed, in a month. And then whoever's living there will be forced out. Well, let's see. Let me put it this way. If an investor buys it and the property is foreclosed, and they bought it as a foreclosure, and if there's somebody still there, that investor or the new owner will have to evict them. Okay, legally evict them, do constructive eviction process. Yeah, I know, because I experienced that. Okay. I'm an investor, and I told one of my clients today, if you're going to be an investor, okay, it is a risk. The day we were born, we are dealing with risk. Became a risk. The day we were born is a risk. Anything and everything we basically do in life and we make a decision is a risk. Could go right, it could go wrong. So investing is a risk. However, it's one of the best ways to invest money. However, be prepared if something goes wrong, that you may have to do repairs, that you may have to take some losses. Or instead of losses, you could get a lot of gain. All right, so that was 17. All right, 18. Okay, so let's see, whoever answered C, Gina, Lisbeth, you answered 20 days. No, in Texas, it's 21 days. Hi, Mireya Trinidad. So is this person actually Mireya Trinidad? Is that who it is? Instead of Sobia Khan. Oh, hi. Yes, I spoke with her, Sobia Khan. 18. In non-judicial foreclosures, the foreclosure price may be less than the loan balance, or it may be less than the market value. With that as a given, which of the following is true? Okay, non-foreclosure in a non-judicial foreclosure, you don't need a judge. That's when there is a deed of trust, and that's what we have here in the state of Texas. The foreclosure price, okay, may be less than the loan balance, or it may be less than the market value. So the amount that's being foreclosed, if it's less than the market value, then there may not be enough money coming in when it is sold to pay off the loan. Or the foreclosure amount, okay, could be less than the loan amount. Okay, you can't concentrate with the music. Yeah, I did ask earlier. So it's my little country western. I forgot to turn it off. All right, it's off. Thanks, Juan. So with that given, which is true, if the foreclosure price is less than market value, the debtor is entitled to an offset equal to that margin. Okay, so what does that mean? So that means that when the property is sold or foreclosed and they don't get enough money to pay off the loan, that debtor, the mortgagor, may be liable for the difference. Okay, so the debtor is the lender, the mortgagee is entitled to an offset equal to that margin. So they're entitled to do a deficiency lien or deficiency charge on that borrower to make sure that that borrower pays what is owed. And this can happen in investment properties and also on personal properties. However, when there was major foreclosures back in 2005 to 2012, there was a Mortgage Debt Relief Act that anybody that was occupying their primary residence and they only had one loan and it brought in less money that was owed, that debt was forgiven because it was happening throughout the US. So the government came and provided some relief. Okay. Wow. Now it seems really quiet. Ooh. But I understand. I can work with music on and study, but some individuals can't. And normally I don't have any. I just forgot. Oh my gosh. No. All right. Number 19. In a judicial foreclosure, judicial means you got to go to the judge, okay? The court issues a judgment to sell the collateral property. See, the court issues a judgment to sell the collateral property, okay? That's the subject property. Following the sale, the debtor has a window of time to determine if there is an excess of market value over and above the sale price. If so, the debtor may obtain an offset for the difference. This window of time is 90 days, 180 days, C, 1 year, or D, 2 years? Number 18, Carlos, was B. If the foreclosure price is less than market value, the debtor is entitled to an offset, the debtor being the lender. So the borrower needs to pay the difference. So there will be a deficiency of lien, a lien deficiency. All right, so number 19. Is it 90 days, 180, 1 year, or 2 years? Okay, this is not a tax foreclosure. In a tax foreclosure, you have a 2-year redemption. This is not that. It's a judicial foreclosure, okay? It's not on a deed of trust. They have a judgment to sell the collateral property, which is a subject property, which is the property that the borrower owns, the mortgage, or following the sale, the debtor has a window to determine if there is an excess of market value. So if they found out that it sold for more than what they owed on that loan, they can get the difference, okay, from what was paid. So this time of window, or this statute of limitation, will be 90 days. This is not a tax lien with lien redemption, tax lien redemption of 2 years. Different type of foreclosure. This is a mortgage loan foreclosure, not taxes. So the A is 19. So 19 is A, 90 days. Most of you answered D, 2 years. You were thinking of a tax redemption probably, and that is for when property taxes are due and they're not paid to the county. Then they file a foreclosure, and they do allow that owner to redeem it in a 2-year period. However, they have to pay 25% interest plus other charges on the first year, or in the second year, 50% interest on the total amount and other charges. Whenever it's sold for more than what was owed on the loan, okay, the borrower should receive the difference after all expenses are paid. And expenses, we're talking about, court filings, attorneys, and da-da-da-da. And you're going to say, what's the da-da-da-da? All other expenses and charges and fees that go along with a foreclosure. All right, Gina, you got it. Very good. Number 20. In a short sale, the sale price is less than the mortgage amount. That is correct. Which of the following is a critical issue for the seller in completing a short sale? So is a short sale mean, it's going to take a short while to sell this property? Or does it have something to do with the amount of money coming in versus the loan balance? So the critical issue for the seller in completing a short sale is A, obtaining an appraisal value that exceeds the mortgage amounts owed. Well, you can't force that, right? B, getting the buyer to agree to make up any deficiency. C, getting the lender to provide a full release of lien at closing. Or D, reporting the correct amount of debt forgiveness to the IRS. Okay, so someone knows the law so far about short sale. So short sale is when a property is being, to prevent an official foreclosure. It's called a pre-foreclosure. So the borrower puts it on the market with a realtor or on their own to get an offer within a deadline by the lender. Okay, in the state of Texas, there's not a lot of time. However, the lender could provide extra time to get the sale done when they have an offer. And so the critical issue is once that lender accepts that offer, even though it is less than the mortgage amount, there's one crucial thing that they want to do. Oh, what did I type? Oh, yes, I'm sorry. 19 is A. You're correct. Oh, my God. Thank you, Lisbeth, for being awake. Lily's the one that's not awake. I looked at a previous, I saw somebody else's answer and I put that. Oh my gosh. Thank you, Lizbeth. So everyone, 19 is A, 90 days. I just went back and corrected my Facebook post. Thank you. Thank you. So yes, the answer for 20 is C, getting the lender to provide a full release of the lien at closing. Because if the lender does not provide a release of liens, then there's going to be a lien still attached on that property, and the buyer, I mean, the owner, okay, the borrower, it's going to show up on their credit reports or anything that they have a lien, okay, that they are behind on. So it's going to ruin their credit. I mean, a pre-foreclosure is going to ruin their credit, but not as bad as a foreclosure. So the thing to do is make sure you get a full release of the lien at closing. Okay, for example, the individual that I met with today, it's a separate issue concerning a property that my buyer is purchasing. Well, their family passed away, right? And they paid off a loan on a car. And they thought it was financed with the dealership. Well, it's not. Well, they can't find out who it was financed with. However, the title still shows that there's a lien holder. And they said, well, no, it was already paid for. And the car dealership says, well, we don't know who your parents used or who they used. And so I said, well, hey, you know what? The DMV is going to have records of if there's a lien on there or who the title is now attached to. So they're going to find out from the DMV, okay, who the lien holder is so that they can request that release of liens. It was not delivered to the owners and they passed away and they can't find out who it is, okay? So they will get a release of liens and now they can transfer title on that car. Similar on here, okay? The title, the property now belongs to the lender. However, on the credit report, there's still going to be, oh, you have a lien on this property that you owned. They're like, no, I don't. Well, yes, you do. Go back and get a full release. A lot of little details, okay? All right, so we started with 16. All right, I'm going to do a couple more state questions, okay? And because I've been keeping it at 5 because there's very few, Texas state questions. And so 21, according to the Texas Property Code, recording real property conveyances has which of the following legal effects? Recording real property conveyances. So when you sell a property or whoever buys it, what does recording do? A, it finalizes the conveyance process. Recording triggers passage of title. B, it causes the transaction to be legally binding on the principal. C, it prevents a transaction from being void with respect to creditors and subsequent buyers. Or D, it enables the buyer to remove all liens of the property. So remember constructive notice. Whenever a property is conveyed, it's very important to record it. So recording real property conveyance, which following legal effects? No, it is not B. Okay. When the property was sold, that made it legally binding on the principals. Okay, it's sold. The deed was conveyed. However, it may have not been recorded. Therefore, it's not constructive notice and not the whole world knows. Okay, so the legal effect, okay, it prevents a transaction from being void. So somebody else can go and, take over the property with respect to creditors and subsequent buyers. Okay, so it was an actual conveyance of property. So recording, okay, does constructive notice for everybody knows, creditors, subsequent buyers, and nobody can say, well, it was a void contract. I mean, it was a void transaction. It belongs to me, okay? You know, those adverse possession. They could go and file and say, well, hey, I've been maintaining it and it was a piece of land. And so I have a right because I've been squatting on there for 10 years or whatever the statute of limitation is on that state. And if they can prove that, they can say, hey, it's mine. And if somebody else had bought it and they didn't go and record it, ooh. So the answer here is C. It prevents a transaction from being void with respect to creditors and subsequent buyers. So without recording, a transaction is not legally in effect as it concerns lenders and buyers. Okay, if a lender cannot reference a transaction in title records, it cannot place a valid recorded lien on the property because there is no record of the owner borrower. According to contracts, it's valid, okay, or going to closing. But if it has a loan on it, it better get recorded because that's what the lenders are going to follow up with, or the public or investors. Okay, so it says if a lender cannot, so it is not legally in effect, okay, legally constructive notice, okay? It's in effect between the buyer and the seller, okay, and the documents that were signed, but they weren't recorded. So there's no constructive notice, okay, and that's when it's recorded. And everyone, including yourself or myself, we have access. We know who owns what property, unless it's an LLC. We don't know who the actual owner is, right? They use that for multiple asset protection. And that's to prevent someone from suing them if they own a lot of investment properties. Okay, so let's see. I've got a question here. So several of you said A. It finalizes the conveyance process. Recording triggers passage of property. Now, the conveyance process was when the owner signed the deed, the warranty deed. They signed it and delivered it to the borrower, okay, at the title company. Then it was conveyed. However, it should be recorded. That finalizes the legality of it. It was conveyed at the conveyance process, at the closing process. Okay, title companies will send it to recording. And attorneys, unless the individual says, hey, attorneys should also do that, and I believe they do, okay, record all purchases and sales at the county courthouse. However, if buyers and sellers do it on their own and whatever, and even though the seller signs the deed and it's delivered to the borrower, but it's never recorded, then how is everybody else going to know? They're not. And if they don't ask for a release of liens, then, well, the lender would know, right? Because the money would have been sent to the lender to pay off the loan, unless the seller kept it and didn't pay the lien, right? The loan. So it notifies everyone of the legality of the conveyance. The signing of the deed, okay, finalizes the conveying property, and when it's delivered, right? It has to be signed and delivered. Actual notice. And it triggers passage of title. But here it's talking about following legal effects. So Texas Property Code, the legal effect is it prevents a transaction from being void. Somebody else could, like I said, an adverse possession could take it over and they can go and record it. Then it becomes theirs. And, okay, got that? So it says, the answer says being void. Can you explain more? Oh yeah, being void. If someone else ended up recording it, they took over the property, or let's say that same owner conveyed it to more than one person, that kind of stuff does happen, okay, from crooks, right? Deceitful individuals. They sold it to multiple persons, and only one buyer went and recorded it in the courthouse. They become the legal owner. So all the other conveyances, all the other conveyances of the property, they become void. They're no longer good. There's no proof other than the document that they have that it was conveyed from the seller to the buyer. And there are sellers, crooks, that have sold the same property to multiple individuals. And whoever goes and records it, that is valid. Now that is legal. The others, they become void. Okay? Void, it's not that it's illegal and it wasn't voided. It's just void because they didn't follow through with recording it. Now, let's say you purchase the property now and you record it a year later. Okay, that's not void unless somebody else takes ownership of the property, as I mentioned. So it's still a good conveyance. However, it'll become totally legal constructive notice for everyone when it is recorded. And you'll get an actual warranty deed with the recorded date, because warranty deeds and not promissory notes, but mortgages are what gets recorded. Okay. Okay, got it. Very good. All right, last question for tonight on Texas State. 22. An essential, let me see if I can make it bigger. Yes. An essential distinction between actionable fraud and intentional misrepresentation is that, so the difference between the essential distinction between actionable fraud and intentional misrepresentation, someone had ill intent to misrepresent, is A, fraud requires two or more parties to commit to the law violation. B, misrepresentation implies that the misrepresenting party did not realize the statement was true. C, misrepresentation requires that the client relied upon the misstatement made. Or D, actionable fraud must have resulted in damage to the defrauded party. So actionable fraud, right? Someone took an action. So far I have B, D. Anybody else? So yes, the answer is D. Actionable fraud must have resulted in damage of the defrauded party. So it says to be fraud, the defaulted party must have relied upon the misstatement and he or she must have incurred some form of damages. Misrepresentation does not imply or necessity entail the two factors. So the fraud entails two. They were misrepresented and it cost them money. Well, I shouldn't say it cost them money. It cost them some damages. Okay. It doesn't always have to be money. It could be a property which is converted to money, right, when it's sold. And misrepresentation is, the party getting the relies on the misstatement made, but there may not be any damage, financial or property damage, okay? So that's the difference. The fraud has to have both misrepresentation, a misstatement, and resulted in damage to the defrauded party. You're guessing D and your guess was correct, okay? That is the essential distinction between actionable fraud and intentional misrepresentation. The intentional misrepresentation, they could have said they knew that this house was a piece of crap, okay, but somebody from out of state wanted it and they sent them a beautiful picture. I saw that in a movie. a beautiful picture of a house that had been updated. It looked gorgeous, like move-in ready. Well, they misrepresented that person, and it wasn't an actionable fraud. That person didn't result in damages. So they arrived there and they're like, oh man, well, I bought the property sight unseen. And they believed what the picture stated. Okay, so that was, with ill intent, that picture was shown to them versus how it actually existed. So did they inherit some damage? Well, they probably did because of all the improvements that they had to make and stuff. However, part of the due diligence was on them. They didn't go view the property before closing. So shame on you, right? So buyer beware. Okay, so that was D, actionable fraud. Okay, any questions before we call it a night? It is, I was going to say Wednesday night. It is Monday night. So remember, you all study lots and lots of questions, repeat them until you get 100 score. I know some of the books say as long as you get an 80% on the questions at the test that you're taking or the quizzes, that should be good enough. Well, a lot of times it is not. The questions on the actual exam can be trickier or harder. And I would say study over and over and over until you get a perfect score. Get different prep books. There's a list of prep books in the description, and you can click and purchase them from Amazon. So anytime you use my Amazon link, Amazon is going to pay me a commission. It doesn't cost you anything. So if you happen to make any other purchases while you click that link within 24 hours, they will pay me a commission. So those are new things that I've learned. And if you ever have a blog or a YouTube channel or Facebook where you recommend things, you can earn money like that. That's another way of earning money. It takes time to grow it, okay? And, study your prep books, study different prep books, go to prep classes, okay? Prep Agent is an excellent one, okay? And, they're together with collaboration with Aceable, and Aceable has their prep classes is through Prep Agent. And study that vocabulary, please. Okay. The vocabulary helps you. You can look up actionable fraud. What does it mean? Intentional misrepresentation. What does that mean? Subsequent buyers. Okay. What does void mean? What does valid mean? What does voidable mean? All right. Those are all vocabulary. So when you ask me those types of words, means you need to go and memorize the vocabulary. Short sale, a mortgage, non-judicial versus judicial, okay? A deed of trust versus a mortgage. What is the Texas Property Code? Okay, that's more of an identification, right? What is conveyance? Oops, I should be showing you the screen. Sorry, I'm going through the screen. What is conveyance? Okay, what's a transaction? Who are the principals? So those are all, vocabulary and definition. Judicial foreclosure, okay, collateral property, okay, a debtor, market value, sell price. All of those are vocabularies, okay, that you need to know. And, offset equal that to that margin. What is margin? Market value, non-judicial. What's a proceeding? You might think notice of sale, notice of default. Those are all vocabularies in the real estate language. So that's just a few of them. All right. So remember to study that. And again, I am a realtor actively working in the San Antonio and South Texas area, only with sellers in South Texas. And so when you're ready to interview and think about who you're going to select as a sponsor, hey, let's chat. Schedule a time on my calendar. There's a link on Calendly, okay, that you can schedule for 30 minutes or an hour in order so that we can review the benefits of EXP as a sponsor, EXP Realty. We are a virtual company, a cloud-based company. We're the Amazon of real estate today. So instead of a traditional brick and mortar office, our office is in the cloud. We provide all the training and education, all the tools and everything, okay, digitally, electronically. Do we ever meet in person? Yes, we do. Okay, so let's talk about that. Any questions before we call it a night? You've been awesome. I thank you for attending, and keep it going. Let's get you to pass. And remember, I affirm, I pass, I pass, I pass. Believe it. So ask, believe, and receive. Catch you all later. Until next time, Wednesday night, 6 p.m. Central Standard Time. Voila.